Welcome to The Explainer. I'm your study mentor. Today, we're going to completely demystify economic torts. And share some really sweet study hacks for your 1L exams. If you've been feeling totally overwhelmed by the sheer volume of black-letter law in your torts class, well, you're exactly in the right place. See, unlike battery or trespass, the lines in economic torts get incredibly blurry, mostly because capitalism inherently encourages aggressive competition. So we're going to break it all down, separate those ruthless business moves from actual actionable torts, and basically get you ready to absolutely crush your finals.
All right, here's our game plan for today. We'll start with mastering the case brief, then demystifying economic torts, dive into fraudulent misrepresentation, tortious interference, good faith and fair dealing, and finally, wrap up with our final exam attack strategy.
Okay, let's jump into Section 1, Mastering the Case Brief.
So when you look at the classic IRAC method, issue, rule, analysis, conclusion, there's one crucial element you really need to consciously leave at the door during a final exam. And that's the story. Look, your professor already knows the facts of the hypotheticals they wrote, right? So for essay exams, you literally do not need to waste valuable time summarizing the facts pattern. You just need to expertly apply these 4 steps to the new juicy scenarios they give you. You're going to jump straight into spotting the issue, clearly establish your applicable rule, analyze exactly how the facts trigger the elements of that rule, and then draw your conclusion.
And here's the absolute biggest secret from a successful student perspective: rule-centric learning. Please don't just memorize the exact facts of a brief you read all the way back in October. Instead of remembering that the plaintiff in some specific case drove a blue Ford or, lived in a certain state, focus entirely on the fact that they owed a standard duty of care. You really want to extract those skeletal legal principles, like the precise elements of negligence or battery. Because honestly, adapting those pure legal rules to a twisted new fact pattern, that is exactly what you're actually being graded on.
Moving on to Section 2, Demystifying Economic Torts.
Now, these are totally unique because, well, you don't need a broken leg or a trespassed yard to recover damages. You literally just need a deliberate hit to your wallet or your business. Historically, courts have been extremely hesitant to award damages without physical injury or property damage, mostly to avoid a floodgate of unlimited liability. But economic torts are the major, specific exception to that rule. They actually allow a plaintiff to recover for purely financial losses. They protect trade, valid contracts, and economic expectancy from deliberate sabotage. When you're building your attack outline, it's incredibly helpful to categorize the big 3 economic torts by their primary focus, just so they're easy to recall under pressure. First step is fraudulent misrepresentation, which hinges entirely on deception and false statements. Second is intentional interference, which focuses on a third party disrupting existing deals or future prospects. And third is good faith and fair dealing. This one governs bad faith conduct between actual parties who are already bound by a valid contract. Keeping these 3 distinct in your head is going to save you massive amounts of analytical time on an exam.
Let's dive into Section 3, Fraudulent Misrepresentation Breakdown.
Okay, time for a Socratic cold call to test those legal instincts of yours. Imagine a hypo where a seller happily sells you an English basement, fully knowing you plan to rent it out. But, oops, they totally and conveniently forget to mention it's technically illegal to inhabit under local zoning laws. So the seller didn't actively lie and say it's completely legal for a tenant. They just kept their mouth shut, cashed your check, and let you assume everything is fine. So think about it. Are they liable for fraudulent misrepresentation? The answer is yes, absolutely. The legal rationale here is that while the statement wasn't technically an outright affirmative lie, the omission created a false impression that you justifiably relied upon to your financial detriment. The law actually treats an omission as an affirmative misstatement in context of asymmetric information, basically where the seller knows a hidden material defect that the buyer couldn't reasonably discover. To win this, you need to prove a material misrepresentation, Scienter, which means actual knowledge of falsity, intent to induce reliance, and justifiably reliance causing damages. Omissions completely satisfy that first element if they paint a deceptively incomplete picture. But hey, watch out for puffery. This is a classic exam trap, guys. If a salesman says a car's the most wonderful ride ever, or a vacuum is a miracle of modern engineering, that's just a cute exaggeration. The courts expect buyers to have a certain baseline level of skepticism, right? Because puffery cannot be objectively verified, a reasonable person just wouldn't rely on it as an ironclad guarantee of material fact. So if your professor sneaks puffery onto the exam, do not fall for it. It's not fraudulent misrepresentation, it's just standard sales talk. All right, Section 4, Tortious Interference Explained.
Now, we have to contrast interfering with an existing contract versus interfering with a future prospective advantage. This is a massive distinction. Interfering with a valid existing contract requires showing the defendant intentionally induced a third party to breach it. But interfering with a future opportunity carries a much, much higher legal standard. Why? Well, because capitalism fundamentally encourages stealing future business and aggressively competing for new clients. However, the sanctity of contract firmly protects existing signed deals. So, for a future opportunity, the defendant's interference must be achieved through highly improper or illegal means.
So here's your next hypothetical, and honestly, this one is notoriously tricky on finals. What if you technically have the absolute legal right to end a contract, but you decide to exercise that right strictly to destroy a third party's business? Think about that for a second. Do you have an absolute shield from liability just because you were exercising a valid contractual right regardless of your motives?
The answer is found in the classic case, Alyeska Pipeline Service versus Aurora Air Service. The court brilliantly illustrates that acting with malice, meaning having the primary purpose to cause economic harm, actually overrides your basic termination rights. In that specific case, Alyeska exercised a contractual right to take over transportation duties from RCA, which intentionally and effectively ended RCA's separate contract with Aurora Air Service. Aurora sued, and the court ruled that because Alyeska acted specifically to financially ruin Aurora out of pure spite, it was actionable. So, a purely malicious motive transforms a standard legal right into an improper interference. Next up, Section 5, Good Faith and Fair Dealing. Here is a classic exam question straight out of the case law regarding parties who are already in a contract. Say an insurance company delays your completely valid payout claim for months. What if they cite an administrative backlog as the excuse to you, but during discovery, internal emails reveal a deliberate strategy to stonewall you right before the Christmas season, hoping you'll just get desperate and settle for pennies on the dollar? Is this actionable as a tort?
You bet it is. The legal rationale here is that you must demonstrate the defendant acted with malice or an improper purpose, not just simple hard bargaining. This tort was specifically developed to address unequal bargaining power. I mean, insurance companies have vastly more financial leverage than a distressed claimant. Stonewalling a valid claim intentionally to force a cheaper settlement isn't just a basic breach of contract. It totally crosses the line into a tortious breach of good faith because it actively sabotages the core purpose of the agreement itself. And Johnston versus Palmer is your black-letter case law for this exact concept. The crucial point here is proving the interference was specifically intended to derail professional success. To win, a plaintiff must clearly define the difference between standard business practices, like, legitimately protecting a bottom line or negotiating firmly, versus actively malicious behavior aimed solely at causing harm. The actions have to step outside the bounds of legitimate business operations and enter the realm of intended sabotage.
Finally, we arrive at Section 6, Final Exam Attack Strategy.
Look, navigating a torts class takes serious strategy. Knowing the doctrine is only half the battle. How you actually deploy it on paper is what gets you the A. While some professors absolutely love explicit headings like issue or rule on your exam paper, many prefer a much more sophisticated flow. Instead of blocky headers, you can often use transition words like here to signal your analysis or therefore to signal a conclusion. A perfectly structured essay that naturally walks through the legal elements shows a much, much higher level of legal writing sophistication.
When you're analyzing economic torts on the final, always use this three-step checklist. First, check the motive. Was it legitimate, rough competition, or pure malice? Second, hunt for improper means, like bribery, physical coercion, or fraud. And third, prove causation. But for causation is honestly often the hardest part of a torts exam. You must show that the economic benefit would have absolutely been realized but for the defendant's interference. For example, if a plaintiff was going to lose a client anyway because of their own poor service, the causation element fails entirely, regardless of the defendant's bad behavior.
And please don't forget to use the fitted cab mnemonic to quickly use the process of elimination. It stands for false imprisonment, IED, trespass to land, trespass to chattels, evaluation of conversion, assault, and battery. When you read a super messy fact pattern, walk through fitted cab first. If a scenario involves a competitor locking a plaintiff in a room to prevent them from signing a contract, you immediately check off false imprisonment before even reaching the economic interference claims. Ruling out physical torts clears your mind to hone in on the pure economic damages. So, as you head into your final exams, ask yourself this one vital question. When you read that complicated, stressful fact pattern your professor cooked up, will you correctly analyze the underlying motive, or will you let the defendant get away with claiming it was just simple hard bargaining? The line between aggressive business and tortious interference is incredibly thin, guys. Stay focused on the rules, trust your attack outline, and ultimately, will you be able to tell the difference between a ruthless capitalist and a tortfeasor? Good luck studying, you've got this.